Good morning, everyone. Welcome to EnviroTech, not the EnviroTech that any of us thought we'd be participating in. This is the third annual EnviroTech. So thank you for joining us. For those that don't know me, I'm the Executive Director at the Environmental Services Association of Alberta, ESA. And I'll be moderating the first session, and then we have other volunteers moderating throughout the other sessions. So first, I'd like to thank our Diamond sponsor once again for the third year, North Shore. And I'd also like to thank all of our sponsors that stayed on board and helped to make this possible. So we really appreciate the support of everyone. Appreciate the support of the 27 presenters who'll be presenting over the next 2 days and the moderators. And thank you to everyone who's registered. We hit 250 registrations. We are very happy and pleased with the support, so thank you so much. So we're going to get started with our first session of regulatory updates. I've popped the agenda up on the screen, and we'll get started. There'll be about a 5-minute, just like if we were doing this in person, there'll be 5 minutes for questions at the end of each of the presentations. Each presentation is about 25 minutes. So we're going to start with expert witness testimony with John Georgakopoulos and Matt Garner from Williams and Shires in Toronto. So John, I'm going to pass over control to you. And you should have control, and the rest of us might turn off our cameras and mics, and we'll let you guys go.
Great, thanks, Joe. Good morning, everyone. Thanks for having us. Matt and I will be speaking to you today about expert witness testimony. During our presentation, we're going to touch on several topics affecting experts. So we're going to talk about litigation privilege, experts' duties and credibility, then move into a discussion about the admissibility of evidence, and we'll then end off with some key takeaways. So let's start with what is litigation privilege. There are different types of legal privilege that apply in different circumstances, and today what we're going to focus on is litigation privilege. So what do the courts tell us about litigation privilege? The courts have said that litigation privilege attaches to documents that have been created for the dominant purpose of furthering litigation. So in order for this privilege to attach, it's necessary that the litigation be existing or contemplated. Also, note that the privilege is that of the clients. If privilege is to be waived, it must be waived by the client. Privilege can be waived expressly or by knowingly giving a copy of the privileged document to one's opponent, or by attempting to rely on the privileged document to obtain some relief from the court. So what does litigation privilege cover? How far does privilege extend? Does privilege reach beyond the expert's final report and into the expert's file? Does all of this mean that the expert's field notes, drawings, notes to self, etc., are producible in litigation? We'll attempt to answer these questions during our talk today. We're first going to discuss how litigation privilege applies to documents, including experts' reports, draft documents, and written communications between experts and legal counsel during litigation. Experts typically produce a lot of documentation, including work plans, field notes, correspondence, photographs, diagrams, meeting notes, draft reports, and final reports. The key question is, which of these materials are producible by parties in litigation? Also, to what extent can privilege be asserted over an expert's work product during litigation? Environmental litigants have broad disclosure obligations in civil actions. In Alberta, Rule 5.5 of the Rules of Court provides that every party must serve an affidavit of record on each of the parties for the documents that are relevant and material to the issues in the action and are or have been under the party's control. Litigation privilege protects documents that otherwise may be relevant and material. But once the expert report is served to be used at trial, the privilege over the documents that the expert reviewed in forming their opinion, whether the expert relied on, rejected, or disregarded the information in those documents, is lost. In Chernetz, Alberta's Court of Queen's Bench explained the rules around expert disclosure. In this case, the plaintiff brought a motion to compel disclosure of documents. In particular, The plaintiff sought disclosure of correspondence to and from counsel, notes on meetings and telephone conversations with counsel and other experts, and claim review notes. In this case, the court held that, and I'll provide the quote, communications between an expert and instructing counsel and working notes created by the expert initially are privileged, as having been created for the dominant purpose of use in litigation. When and if the expert takes the stand to testify, the privilege is lost as to those documents that the expert reviewed informing his or her opinion, whether the expert relied on, rejected, or disregarded the information in those documents. The privilege is also lost on communications between the expert and instructing counsel to the extent that those communications are relevant to the expert's opinion. For example, those communications that may limit or otherwise set the parameters for the expert's opinion. The opposing party on cross-examination is entitled to explore such documents and communications, end quote. Rule 5.35 of Alberta's Rules of Court provides that once an intention to rely on an expert report at trial has been given, the report will either be entered or the expert witness will be called at trial. This amounts to an express intention to waive privilege over the expert's working file. So what about a situation where the plaintiff produces an expert's report to the defendant before trial? In the Grammer case, the court found that the production of the expert's report by the plaintiff before trial did not express an intention to introduce the report into evidence at trial. They also stated that it's common practice to send experts' reports to insurance adjusters and defense counsel with a view to achieving an early compromise of the litigation. The court found that there was no waiver and no express intention to use the expert report at trial. So the court refused to order production of the underlying documents related to the report. I'm now going to turn it over to Matt to talk about communications between legal counsel and experts.
Thanks, John. So John's just gone through how litigation privilege applies to expert reports and other documents. And I'm going to talk about how litigation privilege applies to communications between experts and their legal counsel, because that is a crucial question that has been litigated and commentated on a lot in the past few years. So it's quite timely. The leading litigation case, and when I say litigation, I mean lawsuit scenario in the courts in Ontario that's come out about litigation privilege and this communication between legal experts, expert witnesses and lawyers is Moore and Gedahan. And it's an Ontario Court of Appeal case that frankly, I think provides a lot of guidance about how to go forward with communicating, as John and Jackie and I as legal counsel communicate regularly with expert witnesses. And so it's very instructive. I'm going to read a couple of passages from the case. First, quote, counsel need to ensure that the expert witness understands matters such as the difference between the legal burden of proof and scientific certainty, the need to clarify the facts and assumptions underlying the expert's opinion, the need to confine the report to matters within the expert witness's area of expertise, and the need to avoid usurping the court's function as the ultimate arbiter of the issues. Then the court goes on to say, counsel play a crucial mediating role by explaining the legal issues to the expert witness, and then by pressing complex expert evidence to the court. It is difficult to see how counsel could perform this role without engaging in communication with the expert as the report is being prepared. So that helped a lot of, frankly, legal counsel and environmental consultants and experts, because it gave guidance to the practices, frankly, we were already employing, and the court has upheld that those practices are carrying on. So that's good. Switching to an Alberta case, but before the federal court, but an Alberta-based case, Upnor, Alberta, and Heatlink Group Inc. The federal court added further guidance and said, quote, undoubtedly, consultation and collaboration between expert witnesses and counsel is a necessary component of litigation, particularly in highly technical cases, which are exactly what we deal with all the time, those of us attending EnviroTech virtually right now. So that's helpful too. And then again, in Moore and Gedahan, the Ontario Court of Appeal held at the end of the case that in Ontario, counsel and their experts are permitted to confer in a way that does not interfere with an expert's impartiality and meets the standards of conduct prescribed by both the expert and council's respective professional regulating bodies. Switching to Alberta and the Alberta Court of Queen's bench decision in San Filippo and Alberta Health Services. This is a case where the plaintiff, it's a civil litigation lawsuit, the plaintiff attacked the expert evidence of the defendant by raising concerns about improper communications between the expert and defendant's counsel. And the Court of Queen's bench relied on that Ontario Court of Appeal decision, Moore, that I just went through, where the court held that it would be bad policy to disturb the well-established practice of counsel meeting with expert witnesses to review draft reports. Just as lawyers need and judges need the input of experts, so too do expert witnesses need the assistance of lawyers in framing their reports in a way that is comprehensible and responsive to the pertinent legal issues in the case. So I'm going to switch gears slightly and now talk about what experts do, what duties experts have, and this is general in nature, but it applies to all environmental experts as well. So what do environmental experts do? Well, they decipher, they untangle, they inform, educate, clarify, give opinions. They support their clients and counsel, legal counsel in negotiations, so settlement discussions or mediations. They write experts reports, usually in the throes of litigation and certainly before trial. And then if the matter heads to trial, they testify under oath if their evidence is admitted, which we will get into later. Regardless of the province, experts across Canada have a duty. It's a threefold duty. It's a duty of loyalty, it's a duty to maintain privilege, it's a duty to be truthful and fair. In some jurisdictions, from a procedural standpoint, experts must also sign off on these duties, others they don't. We'll get into that shortly. But what is certainly common across the country is expert witnesses have a duty to the court to give fair, objective, and non-partisan opinion evidence. They must be aware of this duty and they must be able and willing to carry it out. There's a case called the White Burgess case in 2015. It's from the Supreme Court of Canada, which is the highest court in the land. And the Supreme Court said, and I'm going to quote because it's instructive, the expert's opinion must be impartial in the sense that it reflects an objective assessment of the questions at hand. It must be independent in the sense that it is the product of the expert's independent judgment, uninfluenced by who has retained him or her or the outcome of the litigation. It must be unbiased in the sense that it does not unfairly favor one party's position over another. And the acid test, or the litmus test, is whether the expert's opinion would not change regardless of which party retained him or her. That's that nonpartisan piece. So getting into some prescriptive requirements across different courts. So we have Alberta's rules of court for lawsuits, litigation, and they require an expert's report to be in a particular form. And that form is set out in what's called Form 25 under the rules of court. So experts' reports must contain the expert's name, qualifications, information and assumptions on which the expert's opinion is based, and a summary of the expert's opinion. This form and this rule does not require the expert to sign off that they've complied with these expert duties, but these components must be in the report. Switching to Ontario, Ontario's rules of civil procedure, just like Alberta's rules of court, pertain to civil litigation matters, lawsuits, and they require an expert to provide opinion evidence that is fair, objective, and nonpartisan. Once again, those three tenets are key and they come out of the cases and also the rules of civil procedure in Ontario. They require an expert to provide evidence related only to matters that are within the expert's area of expertise. And they require any such additional evidence, or assistance rather, as the court may reasonably require to determine a matter and issue. So another key theme that you're hearing today is the court relies on expert evidence and experts themselves, and will often ask questions during a trial or a hearing of the expert to obtain further input so that the court can make the decision at the end of the day. There's another really key rule in Ontario's rules of civil procedure called Rule 53. And it allows a party to introduce expert evidence if you're going to do so, first by written report and then by oral testimony at trial. But you have to serve, if you're the party who's intending to adduce the expert evidence, you have to serve that written expert's report on every opposing party within 90 days before trial. There is a distinction under the Moore case and it relates to whether experts have to sign off on an expert duty acknowledgement form under Rule 53 in Ontario. And that is, if you're a litigation expert, you're providing opinion evidence about a matter that is germane to the litigation, you have to sign the form. But you do not have to sign this form if you're a participant, or sometimes we call them fact experts. So an example of this is consultants, environmental consultants who conduct subsurface investigations, phase 1s, phase 2s, but don't necessarily provide litigation expert evidence. They may be providing opinions and conclusions and recommendations in their phase 1 or phase 2 reports, but they're not actually being retained for the purpose of litigation. These participant or fact experts may testify at trial for the purpose of what they found and what they did, but they do not need to complete a Rule 53 form unless they're deemed a litigation expert. Switching to the federal court rules also impose duties on experts. Expert witnesses providing evidence at the federal court must sign it, again, similar to Ontario, a certificate acknowledging that they have read this code of conduct for expert witnesses that's set out in the federal court rules, and they have to agree to be bound by it. The code of conduct prescribes that an expert witness has an overriding duty to assist the court impartially on matters relevant to his or her area of expertise. The code also states that this duty overrides any duty to a party in the proceeding, including the party who's retaining the expert. The expert is to be independent and objective and is not to be an advocate for a party. So the upshot from all of what I've just gone through is that although there may be different procedures for litigation experts and participant or fact experts, maybe different procedures depending on the province or the type of the court, the principles that apply to any experts are generally the same across Canada. You have to be fair, objective, and non-partisan. So over to John to talk about experts' duties in tribunal hearings.
Okay, so we've just discussed experts' duties in civil lawsuits. What about experts' duties under administrative tribunals? So for the most part, expert duties are similar or the same, but are prescribed within the tribunal's rules. So for example, the EAB's rules of practice deal with expert witnesses retained by the board. And I'll read a few quotes here in terms of the rules. Rule 24 states that a witness having technical or special knowledge who is retained by the board to give evidence shall provide a written CV of their qualifications and experience. The board, in its discretion, will determine the weight to be given to each witness's testimony, and the witness's qualifications and experience will be a factor in determining the weight to be given to such testimony. And we're going to touch on this a little later in our presentation today. The fact that the evidence is deemed admissible does not mean that it will be determinative of the issue. Rule 15 states that except during examination or cross-examination, there shall be no communication between any counsel and a witness under examination or cross-examination from the time that the witness has been sworn or affirmed until that witness has been excused. The AER's rules of practice also set out requirements for a witness who's presenting documentary evidence at an AER hearing. Rule 24 states a witness presenting documentary evidence at an oral hearing or electronic hearing shall confirm on oath or affirmation that the documentary evidence was prepared by the witness or under the witness's direction or control and is accurate to the best of the witness's knowledge or belief. As well, unless the regulator otherwise directs, the witness must confine witness's testimony to matters set out in the documentary evidence or arising from evidence adduced in cross-examination. Duties for environmental experts are also prescribed within various codes of ethics and guidelines specific to engineers and geoscientists. For example, the Engineering and Geoscience Professions General Regulation contains a code of ethics in its schedule and requires that professional engineers and geoscientists conduct themselves with integrity, honesty, fairness, and objectivity in their professional activities. And again, these are themes that you see throughout, whether we're talking about rules of court or within these individual codes of ethics. So let's now move to the concept of independence. Independence of an expert is an integral element of the expert's duty of loyalty. Bias and advocacy on the part of an expert may affect the weight given to the evidence by the trier of fact. An example of this is an Ontario Environmental Review Tribunal decision in Reitman. So this case involved the appeal of a renewable energy approval that was issued to the approval holder for the construction of a wind facility. The appellants appealed the director's decision to issue the approval, arguing that the project would cause serious harm to human health. The appellants produced an expert to give opinion evidence as a professional engineer. A challenge to the expert's independence and bias was made because he was affiliated with an organization that opposes industrial wind farms. He had also been an advocate against wind farm development and was also one of the local homeowners. The ERT held that the approval holder's submissions regarding bias and advocacy will be assessed by the ERT when weighing the expert's evidence. So an expert's evidence and qualifications must provide a solid foundation and support for their credibility at trial. It's important that experts' reports be independent and unbiased. An expert report is only of benefit to the court if it is independent, unbiased, and it is not unduly influenced by someone having a pecuniary interest in the contents of the report. It's also important that in the expert's report, the expert provide the reasons for their opinions, including an outline of the factual assumptions on which their opinions are based. An expert's credibility is not infallible. Sometimes experts can lose their credibility faster than they can earn it. Losing credibility reflects badly on the expert, on the litigator who retains the expert, and on the litigant who retains the litigator. When discussing credibility, it's also important to note that there may be cost consequences to a party to litigation where the party's expert is found to lack credibility. In C-SPAN, the defendant was ordered to pay costs to the opposing parties when the BC Environmental Appeal Board discovered credibility issues with the defendant's expert report. In this case, the defendant appealed an order to clean up contaminated land. The defendant retained a consultant. The consultant's report concluded that the contamination had not migrated from the defendant's property. During the hearing, the board reviewed the defendant's expert evidence and found, among other things, that the expert's report was deceptive, the expert adopted an artificially technical definition of contamination, the report was constructed so that a reader could not discern the unusual definition of contamination put forth by the expert, and lastly, that the expert's report contradicted conclusions in previous reports. The defendant argued that it did not know about the flaws in the expert's report. However, the board rejected this argument. As a deterrent, the board awarded costs in favor of the opposing parties. Back to you, Matt, now to discuss admissibility of expert evidence.
Thanks, John. A key aspect to consider, no matter what forum you're in, whether it's a court or it's a tribunal, is admissibility of the evidence. And the point that John and I want to impress upon the audience is that it's anything but automatic that an expert's evidence will be admitted as evidence in a trial or a hearing. And there are strict requirements from both case law and rules of procedure, particularly at tribunals, before a court or a tribunal will accept an expert's report or testimony. So what do the cases say about it from the court context? Well, which is largely adopted by tribunals' rules of procedure. The Supreme Court of Canada's judgment in the criminal case Her Majesty the Queen and Mohan is still the leading authority in Canada on admissibility of expert evidence. And I say still because it's it's an older case, decades old, but it's still tried and true and used. So the Supreme Court in Mohan, held that expert evidence should be admitted only if it is, and they gave a 4-part test. First, relevant, which means the evidence must not be related to a fact and issue, but it has to be valuable to the trial itself. It has to be necessary in assisting the trier of fact. So the judge, the justice of the peace, the jury, whoever's deciding the case. It must be absent of the application of any exclusionary rule. So Mohan also sets out a number of different rules for excluding expert evidence and other evidence. Hearsay is one, character evidence is another, for example. And then fourth, the evidence has to be given by a properly qualified expert. So you have to, at the start of a trial or a hearing, qualify the expert, show the court that the expert is someone who, and this is what Mohan says, and I'm going to quote it, is shown to have acquired special or peculiar knowledge through study or experience in respect of the matters on which he or she undertakes to testify. The party tendering the expert is the one who bears the burden of meeting these 4 requirements. So they have to prove or establish that those 4 steps are boxes that they can check off before the expert can provide his or her expert evidence through report form or testimony or both. Gets a little bit more complicated because 2 courts have added on to the list of what's required since Mohan to admit evidence. So the Court of Appeal in 2009, in another criminal case, Her Majesty the Queen and Abbey, added an additional consideration or requirement, and that is that once you go through the Mohan test of the 4 parts, the court must decide if the evidence is sufficiently beneficial to the trial process. And then finally, in 2015, the Supreme Court of Canada, in a case called White Burgess, added a final criterion for admissibility, and it is courts must consider the expert's evidence and impartiality as a threshold to admissibility. In recent years, there have been a number of cases, as you can imagine, that have the courts have commented on expert evidence. Some courts have said that expert evidence is given too much weight and perhaps relied on too heavily in litigation. And so what the Ontario Court of Appeal did in 2009 in Abbey was offer a list of questions that may be relevant in evaluating whether expert evidence, particularly novel or new science evidence, should be accepted. I'm going to quote from or paraphrase a couple of the questions. So the court said, ask this: to what extent is the field in which the opinion is offered a recognized discipline or profession or area of specialized training? What are the particular expert's qualifications within that discipline? And to what extent has the expert arrived at his or her opinion using methods that are generally accepted in that discipline or area of specialization? So over to John now to end with some key takeaways from our discussion today.
Thanks, Matt. So when acting as an expert, it's important to understand the following. 1, the extent and application of litigation privilege. 2, that experts owe a duty of loyalty to provide fair and objective opinions to the court. 3, that an expert's independence and impartiality affect the admissibility of and the weight given to evidence. And lastly, that an expert's credibility is critical and impacts the outcome of litigation. And that concludes our presentation for this morning. Thanks to everyone. And if there are any questions, Joe?
Yeah, if you have any questions for John or Matt, please type them in the question box that you'll find in your control panel. Thank you both for the presentation, much appreciated. I'll give everyone a minute to see if there's any questions. Okay, if there are no questions, you can also, John and Matt's contact information is on screen. You can reach out to them directly. We have a couple of questions for you. 2 questions. Will the full presentations be made available? Yes, sorry. Along with the recordings, I'll send out a link at the conclusion of the event. It should be noted that regardless of an outcome of a court proceeding, when engaged in a court case, the consultant or expert cannot escape the potential of civil suit or challenges to the professional body.
Can you state that again, Joe?
It said it should be noted that regardless of any outcome of a court proceeding, when engaged in a court case, the consultant or expert cannot escape the potential of a civil suit or its challenge to their professional body. Any comment to that?
John, you want me to, I think what the question is the statement is suggesting is that I think it sounds like it's a consultant liability piece, and whether the consultant gives an opinion and then it doesn't uphold and win the day at the trial, maybe there's potential liability for the consultant thereafter. Is that what you're thinking that means, John?
And again, the question's not entirely clear to me, but I think one thing to understand is there are duties and obligations to the court, there are also standards that consultants, must live up to and uphold their practice to. So one issue is in terms of consultant liability, of course, there is the element of negligence. If a particular consultant has acted negligently, surely they can be potentially exposed to civil action and sued. But the other piece is, again, you have to act in accordance with the code of conduct under your profession, right? So if you're a professional engineer or geoscientist, you do have to act in accordance with those codes and guidelines. Otherwise, you could face disciplinary action from those bodies. So I've tried to parse that, what I think that question was directed at, into those two different exposures.
They clarified to say liability does not escape a trial. You can still be liable after, if you presented wrong information or whatever, I'm thinking. One question is, any recommendations regarding file management?
Yes. So when we're talking about environmental consultants, if they're engaged under privilege, it makes sense. And what we often ask is that consultants segregate their files so that it's clearly marked and labeled, whether it's an electronic form or hard copy form, that those documents are privileged and confidential. And Matt, you can speak to that a little bit further, but that is critical. If in fact there's something like a search warrant executed at a consultant's premises, it helps to distinguish and discern what documents are in fact privileged and confidential or not.
Yeah, I'll just add on to that. So our focus today has been on administrative proceedings, so tribunal hearings, and then court cases, lawsuits. But there's that third tier of court cases, but they're quasi-criminal in the environmental realm, whether they're Fisheries Act, as we're going to hear more about today, federal, or they're provincial. And so on that quasi-criminal regulatory side, that's where you see search warrants, and that's why it's very important to mark your file privileged and confidential. And that can play in where you have both a civil proceeding, a lawsuit, at the same time, concurrently running as a regulatory quasi-criminal prosecution, because environmental spills, for example, and events can give rise to both types of liabilities. So a lot of the time you will have an expert who's engaged on both fronts. And so that practice that John just went through is key for both purposes, the court lawsuit piece and then the quasi-criminal prosecution piece as well.
Okay, I think we're running out of time, but just a couple quick things. Comments on, someone stated when they were starting their career, someone once told them take field notes like every page will be viewed by a court. Thoughts on the statement?
Yeah, I think in terms of that statement, the focus on accuracy and documenting, in fact, what you've done and the work that you're engaged in is important. The piece to layer on top of that is, are you doing your work under legal privilege, right? So to the extent that you're engaging yourself and working in accordance with a particular standard, notes are important, definitely. But on top of that, it's important to discern, are they covered by legal privilege? Because then again, the cloak of privilege applies, and you have to treat that information in a slightly different way. Matt? Yeah,
nothing to add. That covers it for sure.
Yeah.
Okay, and then I think we'll close on, do they need to be in a specific format to be admissible, written in pen, signed, bound notebooks?
Yeah, it depends on the specific court procedures. So we went through 3 examples in the civil lawsuit scenario, and Alberta has its Form 25. It's fairly prescriptive. You do have to, you don't have a sign off on Form 25, but there are requirements for what's in your report. Ontario is very prescriptive, federal court's very prescriptive. So you just have to speak to whoever you're working with, legal counsel on the file, and figure out what the form your report should take. One of the things that we do, and frankly, it's an industry standard, is set out questions for the expert. So there are a list of questions that the lawyers think are germane to the issues in the litigation, and then the expert answers those questions. And a lot of the time, those questions and then the answers are set out in the expert's report. So that helps with the procedure, but for the minute details, the minutia of the details of what you need in your report and how to sign off and all that stuff, legal counsel will advise, because it's different province to province and forum to forum.
Okay. Thanks again, John and Matt. Thank you very much. Thanks to Willems and Shires for being such great supporters of ESA and our events. Very much appreciated. We're now going to switch over to Jacqueline Stevens of Willems and Shires and Michelle Heffernan of Trace Associates on environmental practice in 2020, balancing on a tightrope. And I'm going to switch control to Michelle. You should have control.
All right. That's showing up okay?
Yeah, looks good and sounds good. Thank you.
Perfect, thanks. All right. Thanks, Joe. So good morning, folks, and thank you for joining us. Today, Jackie and I are going to be discussing that 2020 it's a difficult year. It's a difficult year for everyone. I know that. And, you know, we're not only facing economic strain, now we're facing a global pandemic. And environmental professionals are really balancing on a tightrope of you know, meeting clients' expectations, trying to meet the expectations of regulators, landowners, third parties, and still produce quality work and operate in a way that's professionally prudent and safe. So a couple of years ago, I think it was at RemTech, Jackie and I had a really interesting conversation in that regard, and we thought it might be valuable to share some of that discussion that we had and discuss some of those common foot slips or scenarios that environmental professionals might find themselves in. And we had a whole laundry list of topics, and we probably could have had a 3-part series with all the topics that we had, but we've narrowed it down to 3 topics that we thought might be interesting for you today. So the 3 items that we're going to be discussing in our presentation are reporting releases and historical contamination, limited scopes and inheriting sites or work products, and environmental services during COVID-19. So the first topic, spill reporting and notification to regulators. This has always been a little bit of gray area as an environmental consultant. That question of when to report historical contamination. I think it's pretty clear for us when spills happen, an immediate spill, how we report, when we report. There's forms that are accessible to us, reporting tools that are accessible to us. It's those older sites, historical contamination, where it's maybe not as clear how we should be reporting that, if we should be reporting it, when we should be reporting it. Industry standard has kind of been to report it is if it's moving off site or if there's a known immediate adverse effect. But there's been a lot of discussion lately with changing regulation, if that's the right way of going about things, or if there's a better way or a more proper way of reporting and when to report. So an example of when we might find ourselves in this scenario of wondering whether we should report or not would be, you know, we have a well site and it's changed hands numerous times. Maybe there's been a phase 1 done, a phase 2 done, and a drilling waste disposal with a drilling waste disposal area with hydrocarbon impacts is identified. We're not sure necessarily who might be responsible for that. Maybe it changed hands at the time of drilling. So the question is, when do we report that? Who reports it? So the first question that I'd like to pose to Jackie, when is a property owner, licensee, or stakeholder legally required to report in a scenario such as that?
Thanks, Michelle. I know you all want a bulletproof answer, and I'm unfortunately not going to be able to give it to you, but I can give you some guidance and tips on what it is you need to look at and think about. So first, you need to look at the law and regulation in your jurisdiction, wherever that happens to be. That's really important because there are words in those documents, obviously, but those words have meaning. And in some instances, those meanings have actually been litigated. So the very first thing I want to show you on this slide is just a paraphrase. These are not copies, but a paraphrase of the types of words in 3 different jurisdictions that deal with the issue of reporting, when to report, who has to report, why are you reporting, those sorts of considerations. And you'll see in each of these, I won't read them, but you'll be able to spot in each of these similar words, such as immediate reporting, by a person who releases, causes, or permits a release, having control of a substance, may cause, is causing, or has caused an adverse effect to the environment or to human health, and reporting when you become aware or you ought to have become aware about a release. So there are common elements across most jurisdictions, but there are also some nuances. So it's very important to understand that. One question that we are often asked as legal counsel is where there's a discovery of contamination, historical or even a current release, what does may cause, is causing, or has caused an adverse effect mean? And that is a very fact-specific review. There's a technical aspect to that, the type of contamination, how much has been spilled or discovered, is there the potential for an effect on human health and the environment? And all of those technical aspects combine in with a legal assessment about these words. And the last bullet on the screen, I put in quotes a lot of these words. And these are the types of words that have been litigated, there's legal commentary on, and they become important in assessing whether a finding of historic contamination needs to be reported or how it needs to be reported, and to whom. So it's really important to have your legal team in place along with your technical team so you can have that discussion when you do discover a historic contamination or you're responding to a spill.
Great, thanks, Jackie. So the next question is, does the consultant have any obligation with respect to reporting?
So a consultant's first obligation is always, I would say, and there's lots of the professional bodies who say the similar thing, you have an obligation to your client, and that's an obligation of confidentiality and other terms and conditions that may exist in your retainer agreement. That being said, you must understand the requirements of your particular professional body and a basic understanding of the law. Sorry, I should have, Michelle, you can just hit forward to get those bullets to fly in. In the normal course, when a consultant finds contamination, historical or not, or is involved with the release or discharge of a contaminant, the first step is to advise your client about that release or discovery, and of the requirements that you understand surround that in terms of the reporting. And then there's the piece about getting legal advice, because not every discovery may be required to be reported. Certainly, don't get me wrong, if there's a spill, there's a reporting requirement. Absolutely. I'm not suggesting that there isn't, but there's also an assessment to be made in terms of when that reporting has to happen. And arguably, if there's no adverse effect, maybe there isn't a need to report. But not reporting can have implications as well. And one of the things that I suggest to consultants is when they are advising their client about a need to report, you also need to suggest if the client chooses not to, you as a consultant may also have obligation to do the reporting, that you then need to seek legal advice to determine whether that's something that you need to take a step to do. Of course, letting your client know that that's your intention.
Great, thanks. Are there any examples of legal action being taken for failure to report with respect to releases or historical contamination?
Yeah, so in terms of legal action, the failure to report is an offense. So it can be something that is prosecuted for. So we need to keep that in mind. There is an element that you have to consider. Often we see prosecutions where failure to report is part of the list of offenses. It's not all that common, although it exists, to see failing to report as the only reason that the matter has come forward. There's also been case law that has expanded on the words that I spoke about earlier, all of those key terms. And one such case is RV Edmonton from 2006, where the court considered the language of the statute to determine if a failure to report a release had actually occurred. And the court actually spent 69 pages looking at and considering the words of the statute and what they meant and how they had been treated in previous cases and just how they should be looked at in terms of their ordinary meaning. Some of those words were release, person who releases or caused or permitted, cause is causing or may cause an adverse effect, and others. As part of the review, what was interesting in the Edmonton case is that the court also looked at the creation of a secondary class of category or person who may be required to report aside from the actual polluter. And this opened up further that category of reporting by someone who subsequently discovers contamination, even though they didn't put it there or they didn't act to create that event. And this is a way to expand the breadth of how environmental issues are being brought to the attention of the regulator. It may be that the person that discovered the contamination is not the person who released it, but does have control or charge management and control, and I put it in quotes because that is a language from the legislation where there are obligations that to report. The court did also look at the term charge management and control, and they indicated that the phrase should be considered not only in its ordinary meaning, but also a purposive meaning, essentially expanding potentially the breadth of what charge management and control means. You might not have put the contamination into the ground, but perhaps now as a property owner of that contamination, you have to consider that you do have charge management and control. That's what the court was trying to get at. As I said, I know you want an answer, but there is no one size fits all response. Each case has to be assessed based on the facts. What was spilled? When was it spilled? How much was spilled? Did it cause an adverse effect? Can it cause an adverse effect? So it's a much broader question than just, do I have to report historic contamination that was discovered? So I put up here 3 cases, and I don't want to take a whole lot of time, but just to illustrate some differences. So Chem Security, it's an older case from '98. This is where there were some puff samples from a flue gas stack, and the company getting these samples didn't prompt them to report, but it did prompt them to make some changes to their operations. And it was those changes that ultimately caused a major release that they were prosecuted for. And in that case, a couple of things to take away is that it was about dealing with an extremely toxic material in an environment where it was a self-reporting and self-monitoring and reporting environment. And the effect of a failure to report could be very serious. And in those situations, that failure to report could result in great damage. So that was an important piece to consider in terms of that review. The Shell Canada case from 2000 was a case where, as I mentioned, usually you see failure to report with other things. So in this case, Shell unlawfully applied a pesticide, and then failure to report the release was also part of those charges. And Shell had used a slimicide to address a microbiological issue in their cooling tower system, and the cooling tower water discharged to the sewer, which eventually went into a creek. And the initial test said, no problem, there was no fish mortality, good to go. So Shell applied the same slimicide a second time. And the second time, the results came back and said within 24 hours, 20% of fish were dead, and within 48 hours, all of the fish were dead. And here's where it gets a little interesting. There was an attempt to fax, this was back in the fax days, to fax the results to Shell, which didn't go through. They eventually received the results by snail mail, and when they reviewed the results, they reported. So the court, what's instructive for us from this decision of the court is that although the failure to report is a strict liability offense, which means the Crown just has to prove that you didn't report, there's nothing else kind of around it. That's what there's also the requirement that in the legislation that said immediately upon becoming aware. So there wasn't the knowledge attributed to Shell that they knew about the release prior to the time they actually reviewed those records that they got by snail mail. And the other piece, which is helpful in assessing, is that the court argued that they needed to know that the knowledge of the release by itself was enough, and that they didn't have to know that it had actually caused an adverse effect, so that fish mortality. But the court said that doesn't make any sense. If we take that away, that the meaning of had, caused, is causing, or may cause, it renders that portion of the legislation meaningless. So that means to us that we have to consider that phrase and how that fits with the facts of the situation. The final case I noted is one where the only offense that I could find information about was an actual failure to report. There were no other offenses to my knowledge. Maybe there were, but when we get reports of some of these prosecutions, you get very little information, but it suggested that it was a failure to report a release of anhydrous ammonia for 4 weeks. And that was enough to trigger a prosecution and resulted in a $28,000 fine.
So, Jackie, most of the cases that you found were based on immediate releases and not based on identifying historical contamination and not reporting that. Is that correct?
That's correct. I haven't seen, and that's not to say they don't exist or haven't existed, but generally the situations where it's been historic contamination, the objective is actually to deal with it and get it cleaned up. And most often, if there's some prosecution that flows from that original discovery, it relates to failing to take remedial measures, failing to remediate, which is also a requirement of the legislation, or failing to comply with an enforcement order that may have been issued to deal with the contamination. So I wasn't able to locate and haven't seen in my years of practice a situation where a prosecution happened because of the discovery of, or failing to report the discovery of historical contamination. But that's not to say it couldn't. And I want to make sure that people out there who are listening don't think automatically, oh, it's historical, I don't have to report. That's not the message. The message is you need to consider whether you need to report, because there are reporting obligations that may apply.
Perfect, thank you. A little lag in my slides here, so bear with me. There we go. Okay, so the next topic we wanted to discuss are those scenarios where you maybe have limited scopes, maybe your budget's been tightened and you might have to reduce what your original scope might have been, or you're inheriting work products from other consultants. So with budgets in this day and age typically being tight, companies are often forced to reduce those budgets and reduce scopes, cut costs. And often we find that the scopes that we end up going out into the field with maybe aren't as robust as the scopes we might have recommended in the first place when first taking the preparing the first work plan or first proposal. And it's sometimes difficult to make an informed conclusion on a site with that limited scope. The other scenario is when one consultant might have those limitations, and then that work is then passed on to the next consultant in the next stage of work, the new consultant might question, were all the steps taken at that last step? Because we know this particular budget might be tight. And struggling a little bit to rely on that work that's passed on, having not done it ourselves and maybe not knowing what all's gone into it. So an example of that would be, you know, consultant A does a bare bones phase one. Perhaps it was a program that was a bid was sent out, and the budget's quite tight. And then the consultant A determines that no phase two is required, and they pass that site on to consultant B for reclamation closure. So consultant B now is in a scenario where they have a phase one that has said no phase two is required and the site's ready for reclamation. So the question is, how can consultants balance those needs for restricted budget and the expectations of the client with the expectation from regulators and our professional institutions?
Yeah, it's a question we get fairly frequently, and there's a couple of key elements to it. Mostly relating to communication with the client. So it's really important to talk to the client about what their objectives and purpose are, so you have a good understanding of what they're looking for from you. You also want to assess what are the necessary requirements and components that have to go into the scope of work in order to meet those objectives. And that's based on your expertise and your knowledge, both of science and also the regulatory requirements. And that's when you're going to, that's what you're going to base and prepare your scope of work off of. So it's important to have that initial conversation, and then it's important to have a conversation about the scope of work that you do ultimately provide. And that conversation will often revolve around the client asking questions about what you've proposed and why you're asking them to pay for 6 monitoring wells when only 3, they'd rather pay for 3. And that's where expertise and knowledge really help in coming in and explaining to the client the rationale behind what it is you're proposing, especially if you know that the information has to go to the regulator and you've submitted information to the regulator before and you have an idea what a regulator expects in order to meet certain requirements. And it is about you going back to your client and saying, if we don't do this scope of work or some revised that still fits these requirements, the regulator is not going to accept the report. They're going to send it back to us. They're going to make us do more work, which ultimately will be more expensive for the client. So it's all about having that discussion, setting out your scope of work. And then if in fact client says, no, please don't do, you need to confirm that back to client in writing that you've been advised not to undertake a scope of work that you had otherwise suggested. It may also be appropriate that your report has in its conclusion that the conclusions are based on the scope of work. You don't need to write in your report that you propose something more and the client said no, but you can create at least a tie back to your scope of work, and that being the scope of work that was approved by the client. It really comes back to that conversation and discussion. And a lot of the times the fear of having to pay more because you didn't do enough in the first instance is often what's needed to prompt a client to do a more robust scope of work initially.
Great, and I think that there's also the case that, you know, you can always add on to that initial scope of work. So if you do the work and there's not necessarily enough information that's been collected, recommendations for taking additional steps can be made to the client. So even though that original scope might be a little bit tighter than you'd like, doesn't mean that's the end of the story.
Yeah.
So the next question is there guidance available with respect to the steps that consultants should take when inheriting sites or work products from other consultants?
So there are, and definitely where you are being given reports that you're now being asked to rely on in either developing a further scope of work or taking the next step in the project. And you have to very carefully review that information and consider the work product to make sure that it does meet the requirements. So in your example of the phase 1, did they access all of the information that you would normally do for a phase 1? Did they go out and have interviews with the entities at the property, the people at the property? Did they assess as you would have assessed to get to their conclusion that a phase 2 wasn't required? If you can't get to the point where you are comfortable with the work that was done to be able to go to the next scope of work, obviously, again, conversations with your client, they're very important, but that's also where you can work into your scope of work, that data gap analysis or information that you found missing to be part of the work product that you're going to prepare for the client. And then from there, you can then create and hopefully take the next steps that you have planned. There is some guidance documents that are helpful at any time, but may be helpful in terms of reviewing work and ethical obligations. Oh, sorry, I'm just going to back up one step. The last bullet that Michelle just pulled up, it's really important for you to document your instructions from your client. And I mentioned that in the last slide, both in terms of what you're being asked to do, but also in terms of what you're being instructed not to do. And then in terms of guidance documents, all of the different professional bodies have guidance. I pulled up 2 from APEGA, guidelines for ethical practice, as well as there's some draft practice standards for relying on the work of others and outsourcing. And although that's about you working directly with other individuals or engaging someone in a different field, some of the same principles apply in terms of how you review someone else's work that you now need to take and move forward. And I also put up the joint document that's between 6 or 7 of the professional organizations about responsibilities for completing work, reclamation and remediation work in Alberta. There are a ton of guidance documents, and it's certainly worth reviewing them. Probably quarterly, maybe more frequently, but I'm pretty sure there's a number of folks on this webinar who maybe haven't cracked them since the original time that they got their designation. So, but they're well worth looking at.
Great, thank you. So our last topic that we wanted to chat about today, being very timely, considering you can see most of us are still working from home in this new COVID world, is conducting environmental work in the time of COVID-19. You know, as we navigate these unprecedented times, it seems that there's guidance being rolled out and orders being released, decisions being made, and sometimes it can be vague. They seem to be evolving daily and can be really, really confusing. And I think that the public and clients and environmental professionals are all really struggling to determine, one, what is actually considered an essential service, because depending on the area you live in or the professional body that you are a part of, you may or may not be considered an essential service. And then what scope of work might be considered essential, even if you yourself are considered essential or your profession is. And it really leaves us all questioning truly what is essential and what is not. So it's important to think about those sites too, where we have an approval or guidance that mandates us to complete a certain scope at a certain time of year, whether it's an APIA approval or something similar. And we have seen some relaxation of requirements that have come out. AEP and AER have both released some information, and there's just continued confusion. One of the examples, AEP released the ministerial order that delayed reporting requirements for some APIA approval sites. And AER released a decision that allowed for spring monitoring to be suspended in some scenarios. And the two bodies have taken two different paths forward on this. So it's just building this confusion for a lot of us. So my first question with respect to this would be, what is your interpretation of essential service with respect to environmental work?
So that's a great question. Each province and territory is different. They've all created their own lists of what are essential services. And some of that came from guidance from the federal government, who created their own list of essential services that looks at critical infrastructure and services for health, safety, security, and economic well-being. But the real piece of that is that you still have to look at what's required in your province. So if when Michelle can, we can advance to the next slide. I want to just touch on the Alberta list of non-restricted services, and this is by no means the full list. And I did put the link up there, but just as to point out a couple of areas where there may be some confusion in the public safety and security area or services. Environmental emergency response and regulatory enforcement services are not restricted. For industrial areas, businesses and services that support security and the safe and reliable operation of high-risk sites and facilities, or supply products to the mining and mineral production and distribution sector, they're not restricted. And there's certainly things that environmental consultants and practitioners are doing in relation to those industries. Under other essential services, professional services, including lawyers, paralegals, engineers, accountants, and translators. And I think you can fit in there your professional agrologists, chemists, those types of roles in the environmental consulting world. There's also a specific indication about environmental services for agriculture, mining, oil, and gas. Those are not restricted services. So based on that, it would seem that there is a body of environmental work that can continue as non-restricted services, of course, subject to meeting the public health requirements.
Great, thanks. So the next question is, what's the current direction from AEP and AER?
So I think you've summarized that fairly well in your intro there, Michelle. Essentially, AEP has issued several ministerial orders, most relating to reporting deadlines, and that those deadlines have been extended or suspended. And just a reminder, I believe there are at least two where the reporting deadline is now June 30th. So you got a couple of weeks to get that done. But for AEP, it seems not much has changed in terms of requirements for doing your monitoring and complying with other elements of your approvals and orders. AER, on the other hand, issued two decisions on May 20th, where I understand it was in response to requests from operators because of an inability to undertake both monitoring under environmental obligations and to comply with the required COVID-19 restrictions. And the idea was that they didn't want, the operators advised AER that they couldn't do both. To be in compliance with one would mean being out of compliance with the other. So if we flip to the next slide, it just kind of gives a summary of the Alberta Energy, the AER decisions, and I'll just keep talking. Essentially, there's this temporary suspension of some of the monitoring requirements for operators under the Oil and Gas Conservation Act, as well as in situ oil sand projects, where they have APIA, Water Act, and public land approvals. Some of the restrictions or the temporary suspensions relate to soil and groundwater monitoring, except for essential monitoring, that still has to continue, except for emergency response, that still has to continue. But there is a requirement that a groundwater monitoring resume by September 30th, and that there is one monitoring event in 2020. Interestingly, both of these decisions came into effect immediately after they were issued, and subject to the September 30th requirement date, Otherwise, they are in effect until directed otherwise by AER. So I was doing some, online searching, and actually AER issued a statement on June 9th, just a couple of days ago, about why they put the temporary suspensions in place. And it was to deal with, they say, the conflict between having to comply with two different laws that may not be easily meshed together. And AER stated that it adopted some guiding principles in order to make those decisions to determine the effect of what a temporary pause of those monitoring requirements would be, and that what they decided was those that were temporarily suspended were of low risk to public safety and environmental outcomes. They're saying they're helping with compliance. They're preventing people from working too closely. They're also preventing people from traveling within and outside of Alberta in order to respond to the environmental compliance piece.
Great, thanks. And our last question that we'll just breeze through, as I know we're limited on time here. Do you think that there'll be some lenience for those scenarios where you might not be in compliance?
I expect, don't know for sure, can't guarantee anything, but I do expect there will be some lenience for non-compliance. However, you're going to need to be able to provide an explanation why and a plan to get back into compliance. My suggestion is, if you think you can't comply, that you get in touch with the regulator sooner than later, and you need to consider that both with your technical team and your legal team. But usually asking about how to change your compliance obligations is better. I don't think simply saying because of COVID-19 will be sufficient. There has to be some additional element, because we do know that most environmental work can continue as long as you're able to follow those public health and workplace policies. And I understand, Michelle and I were talking about this, that there may also be some misunderstandings even within AER or AEP, and one in particular was AEP questioning why reporting hadn't been done despite their own orders. And it just could be a misunderstanding within the overall government structure. AER notably has also said that they will be reassessing the temporary suspensions once the expected announcements come tomorrow about updates to health directions from the government of Alberta. So the key message is stay tuned and keep informed about what you need to do in the COVID-19 time.
That's great. And, I have heard some examples as well of companies requesting lenience for canceling spring monitoring, and the AER has responded, AEP has responded and said there won't be lenience in that spring monitoring still needs to be conducted. So
that's important information to have that conversation and find out, rather than after the fact, trying to dig yourself out of that non-compliance that could be prosecuted.
Exactly. Great. Well, that wraps up our presentation here. Oh, there we go. So I'll give it back to you, Joe.
Thanks, Jacqueline and Williams and Shires, and thanks Michelle and Trace, and Trace for being such a great supporter of ESA. I think we're running late, partly my fault for not controlling questions on the last one, but I have one question so far. If someone purchases a historical contaminated site, but there is no information on the contamination available until the person planned to redevelop the land and get ESAs done, and if the polluter is still in business, who is responsible for the cleanup costs?
I know it sounds like a cop-out, but that's really a question that's beyond the scope of the discussion. But here's the thing, you need to engage with a lawyer and your technical folks to decide whether there's a reporting requirement, or maybe AEP already knows, for example, how you're going to report. Maybe you need to bring a lawsuit to try and get the original polluter to pay. There's a varied number of elements to that question. And and I'd be remiss to try and give an answer without more background. But maybe you get to go back to the polluter in a forum like a lawsuit or maybe a demand letter and ask them to ante up the cost of that remediation.
That's fair. I think we'll leave it there. There's no other questions. So thank you again. I really enjoyed the format of your presentation. I think that's a model to look at going forward for presentations, even in person. So thank you for that. We're now going to switch to Robert Best with Integrated Sustainability. The Fisheries Act has changed. Are you covered? And Robert, I see you're already up on the screen. That's great.
Thanks, Joe. Well, I just want to say again, thank you again for the opportunity to present at EnviroTech. It's been a couple of years and ESA's done a fantastic job, so I just want to make sure that I say a huge thanks to those hardworking folks. My name is Robert Best. I'm an aquatic biologist and the manager of water resources at Integrated Sustainability. Today, I wanted to speak to you about some of the changes to the Fisheries Act and to really just ask the question, are you covered? So I'd like to provide you with a bit of a brief overview of my presentation today. We'll try to get through it quickly just so we can try to keep people on schedule here. So first, I'll start with how we got where we are, some of the major changes to the Fisheries Act, what are letters of advice, and I'm going to finish with a case study to speak about the DFO request for review process. So how did we get here? Well, in November 2015, the Prime Minister mandated Fisheries and Oceans Canada, as well as the Canadian Coast Guard, to review the previous government's changes to the Fisheries Act and restore what they felt to be lost protections and also incorporate modern safeguards. This eventually included the National Energy Board, which is now the Canada Energy Regulator, and other government ministries. In the fall of 2016, the Government of Canada requested Fisheries and Oceans conduct a study to review the 2012 changes to the Fisheries Act. To support the review, DFO undertook engagement with Canadians and had approximately 70,000 unique visits to the website and also received almost 1,700 written submissions. In February 2017, the report was released, and all these background and engagement documents are readily available on the DFO website. In February 2018, the Government of Canada introduced Bill C-68 in order to, again, restore what they felt were lost protections and incorporate modern safeguards. So royal assent is a process by which a bill becomes an act of parliament and part of the law in Canada. In June 2019, most of the provisions in Bill C-68 came into force. Some of these provisions include the new purpose of the Act, new Indigenous provisions, and new considerations for decision-making. On the 28th of August 2019, the new fish and fish habitat protection provisions came into force and replaced the fisheries protection provisions of the pre-royal assent Fisheries Act. So that is how we got to this point in time. One of the most important changes was reverting back to the prohibition against the harmful alteration or disruption or destruction, or a HAD, of fish habitat, which is designed to provide protection for all fish species and fish habitat. As a result of this amendment, the prohibition against works, undertakings, or activities causing serious harm to fish that are part of or support a commercial, recreational, or aboriginal fishery was rescinded. The change to HAD from serious harm to fish is impactful. However, in my experience, the majority of projects I've been involved with were required to consider potential impacts to all fish species, as it was very rare to encounter a fish population that was in no way associated with a CRA fishery. If you think of it plainly, even brook stickleback and other less desirable fish species, for example, minnows or suckers, support CRA fisheries as prey species for more flashy specimens such as trout, walleye, or pike. Some additional changes included, but again, I should say are not limited to, restoring a prohibition against causing the death of fish by means other than fishing, strengthening the role of Indigenous peoples in project reviews, monitoring, and policy development, promoting restoration of degraded habitats, allowing for better management of large and small projects impacting fish and fish habitat through a new permitting framework and code of practices. Some of you may remember DFO operational statements. They're probably close to 10 years old at least now. While not coming back in their same or original format, code of practices are currently under development and a timeline for their release has not yet been confirmed. There are 2 code of practices, one of which I will touch on later on in this presentation. Also, provide improved protection of fish and or fish habitats that are sensitive, highly productive, rare, or unique through the designation of ecologically significant areas, consideration of cumulative effects of development activities on fish and fish habitat, and lastly, establish a new requirement to make information on project decisions public through an online registry. So in that transitional period between royal assent and coming into force, there were projects submitted to the DFO for review, some of which required project authorizations. This seemingly complicated flowchart provided direction on which Fisheries Act was needed to be followed. However, for many proponents with, quote, temporary water intakes, say water intakes that can be removed from the water body relatively easily, compared to something that's more permanent, this didn't provide any direction. That is because proponents of projects that required review, but not a project authorization from the DFO, often received a letter of advice. So what I have up on the screen here is just the first page of a standard letter of advice that I've received in the past. So letters of advice are non-regulatory tools currently issued to provide advice to proponents on the implementation of appropriate measures to avoid and mitigate harm to fish and fish habitat, to assist them in complying with the Fisheries Act. Proponents are responsible for complying with the Fisheries Act. Letters of advice are typically the end result of standard water withdrawal projects that has undergone a project review by DFO. So typically, the letter of advice would include a high-level description of what the proponent has told the DFO that they plan to do, what information DFO has considered in their review, for example, reports, communications with provincial regulators, etc., what mitigations in addition to what the proponent has included are recommended by DFO, a determination of whether the project is likely to cause previously serious harm to fish, or now whether there may be a had of fish habitat. If a had is likely, then the DFO reviewer may recommend that the proponent revise the planned activities or apply for project authorization. So letters of advice that were issued prior to coming into force of the fish and fish habitat protection provisions may not adequately protect fish and fish habitat in accordance with the amended Fisheries Act. For example, the, quote, serious harm to fish prohibition of the previous Fisheries Act did not actually encompass temporary alterations to habitat. Typically, only permanent alterations were considered. The new HAD regime does so by capturing disruption of fish habitat. It is therefore the responsibility of the holders of letters of advice to verify if additional measures should be implemented in order to remain compliant with the Fisheries Act. Therefore, the DFO recommends that proponents have previous letters of advice. When I say previous, I mean pre-August 28th, 2019, reviewed by a qualified professional to determine if additional DFO input is required to maintain compliance with the Fisheries Act. I should note here that no letters of advice are grandfathered. That was a specific statement from DFO. You can find that on their website as well. So I want to jump into this case study, and I'm going to focus on Alberta, but DFO's mandate is Canada-wide, so you can just swap out, Water Act with Water Sustainability Act if you're interested in British Columbia, as well as land getting permission for land use, Crown land or private land, as well as First Nations consultation. So really, what is the process for getting a surface water license approved in Alberta? It breaks down into 4 basic steps. Applying for a Water Act license. This can either be a temporary diversion license, TDL, or term license. Second would be getting access to the land, and that can be through a Public Lands Act application. Often it's a license of occupation or a temporary field authorization on Crown land, or if you're on private land, you need the written approval from the landowner. Thirdly would be completing First Nations consultation. Typically, this is done through the Aboriginal Consultation Office in Alberta. Should your project require a DFO review, they will absolutely ask you if First Nations consultation has been completed, as that is now part of their new mandate. And lastly, is determining whether the project needs to be reviewed by the DFO. So for the purpose of this case study, I'm going to assume that the first 3 items have already been taken care of or are in progress. So let's talk about the DFO request for review process. I've broken it down into 5 different pieces. What is it? Is it required? What is the process? How long can that process take? And what happens if I choose to not submit my project for DFO review? Well, in many cases, we've heard, I have my approved license from the AER. Isn't that good enough? Well, unfortunately, the answer is project dependent, and often no, having a Water Act license is not enough to maintain compliance with the Federal Fisheries Act. Engagement with your qualified professional towards the beginning of a project will help you understand whether or not the project will require a review by DFO, and therefore can be factored into your project schedule to help avoid any unforeseen delays. So it is a process for determining whether a project or specific project activities require a review by DFO before commencing. It provides proponents with an opportunity to verify with the DFO that their mitigation measures are appropriate, sufficient, and in compliance with the Fisheries Act. It provides DFO with an opportunity to recommend additional mitigation measures if necessary, or to engage with provincial counterparts to review potential cumulative impacts to reduce the likelihood of a had of fish habitat. It also provides proponents with an opportunity to adjust project activities if a had of fish habitat is expected, to avoid needing to apply for an authorization under the Fisheries Act. So we often hear from proponents who are sometimes frustrated that this is a quote double review. While we don't necessarily disagree, I've put this question to DFO and AER reviewers, and really the answers don't fluctuate much. The DFO often reviews with a slightly different lens on ecological flow requirements when compared to the AER. The AER typically relies on the Surface Water Allocation Directive, water conservation objectives if they exist on the water body, previously the Alberta Desktop Method, and also proponent supplied information for the impacts to the aquatic environment. And so the DFO typically relies on proponent supplied information as well, in addition to peer-reviewed advice found within the framework for assessing the ecological flow requirements to support fisheries in Canada, which is an article that was produced by the Canadian Science Advisory Secretariat of the federal government. So regardless of the recent amendments to the Fisheries Act, the requirement to have a project reviewed or not by DFO really have not changed. Previously, proponents could follow the quote self-assessment process to determine whether their project required a review. However, this has been replaced and the new system uses much of the same information, just really in a different format. The 2 main considerations to determine whether your project requires a review are: 1, does the water body in question require a review? And 2, can your project follow all of the measures to protect fish and fish habitat? So the emphasis on all should be noted there, as this will come into play a little bit later. So for the first consideration, which is water body specific, a project review by DFO is not required for water bodies that include artificial water bodies that are not connected to a water body that contains fish at any time during any given year. For example, private ponds, roadside drainage ditches, quarries or aggregate pits, irrigation ponds or channels, stormwater management ponds, agricultural drains and drainage ditches, commercial ponds like golf course ponds, or even stocked fishing ponds. Or any other water body that doesn't contain fish at any time during any given year, or isn't connected to a water body that contains fish at any time during any given year. So next we move on to the second criteria, whether your project can avoid all measures to protect fish and fish habitat. If you can follow all the measures to protect fish and fish habitat, you do not need to request a review by DFO. So measures most relevant to water withdrawals from fish-bearing water bodies include, and again, this list isn't fully a comprehensive list. This is just some of the ones that are most relevant to water withdrawals. So avoid causing the death of fish. Avoid the had of fish habitat in your work, undertaking, or activity. Maintain an undisturbed vegetated buffer between on-land activity and the high water mark of any water body. Avoid disturbing or removing materials from the banks, shoreline, or water body bed. Avoid obstructing or interfering with the movement and migration of fish. So of those measures just listed, most are avoidable through proactive project planning. And so continuing on, undertake activity to respect timing windows. So in Alberta, respecting the restricted activity period of a particular water body in question. Avoid conducting work or undertaking or activity in water. Avoid placing fill or other temporary or permanent structures below the high water mark. And avoid changing flow or water level. So this second set are often unavoidable and typically will lead you to requiring a review by DFO. It should be noted that not being able to incorporate any single item off those lists that I just read necessitates a review by DFO, as you can no longer incorporate all measures to protect fish and fish habitat. If your project is located on a water body where DFO review is not required, then you don't need to consider whether your project requires a review based on the measures that I just provided, as it doesn't apply. However, if your project is like most proponents who are looking for a reliable surface water source for development activities, then they need to consider their project activities and whether, again, they can incorporate all the measures to protect fish and fish habitat. Incorporating some still requires a review. You need to be able to incorporate them all. So at this point, this is where we come down to an inherent need for DFO reviews on water withdrawals from fish-bearing water bodies in Canada. The reason for this is, I'll restate this, water withdrawals from fish-bearing water bodies are often unable to respect the restricted activity period. So if you have year-round water withdrawals, if you're going to be placing or repositioning a water intake during the RAP, you can't meet that, that requirement. So the next one would be avoid conducting any work, undertaking, or activity in water. Water withdrawals at their core are activities in water. Avoid placing fill or other temporary or permanent structures below the high water mark. Well, this can include the fish screen, water intake designs that rest on the bed, that float, or more permanent designs such as riverbed infiltration galleries or riverbank intakes. And this also includes all project material below the high water mark, so any anchors, hoses, or ropes as well. And lastly, avoid changing flow or water level. So any water withdrawal constitutes a change in flow regardless of the rate, the duration of the withdrawal, and the volume. Therefore, there's an inherent need for all surface water withdrawals, both in Alberta, TDL and term licenses from fish-bearing water bodies to be reviewed by DFO to maintain compliance with the Federal Fisheries Act. So this seems to be controversial with different messages coming from different proponents and different consultants, but one message has always been the same from DFO. For any water withdrawal in Canada that is from a fish-bearing water body or that is connected to a water body that contains fish at any time during any given year, a review by DFO is required. If you're told your water withdrawal project from a fish-bearing water body doesn't require a DFO review, I would recommend you ask why and get it in writing. In the end, it's your responsibility to be compliant with the Fisheries Act. Recently, the AER has actually begun to provide feedback related to TDLs from fish-bearing water bodies that the proponent must, and I quote, just got this from a proponent the other day, I quote, request a project near water review from DFO when the works, undertakings, or activities do not meet all the criteria listed in the interim code of practice. And so that was one of the code of practices that I spoke about recently. And so we'll jump into that interim code of practice issued by the DFO. And under section 2, it states that you can use this code of practice if you follow all 3 conditions in that section. And so one of those 3 conditions states that you can use the interim code of practice if you incorporate the measures in this code of practice and all other applicable measures to protect fish and fish habitat. So as you can see, from what we just discussed, it is inherently difficult or functionally impossible to meet that condition, and therefore we get back to the same requirement to have your project reviewed by DFO. So now that we've established that a DFO review is necessary, what is the process for initiating it? First, you complete your DFO request for review form. You can get it on their website. I recommend downloading a new one each time as they update it periodically. This form really should be completed by a qualified professional with past experience. This will help with the cost effectiveness to your business and efficiency of the review by DFO. It really just helps reduce supplemental information requests or needless back and forth with the regulator. And how much information you provide is really based on a number of variables depending on the potential impact of project activities, the rate, volume, and duration or timing of your withdrawals, availability and the quality of the fish habitat or the sensitivity of the water body in question, and lastly, the presence of federal or provincial species at risk. In Alberta, the submission goes to Central Arctic. In BC, it goes to the Pacific Region Office. So this is, I'm not going to go through the forms in detail, but this is a typical form. Information that's included is your typical contact information, basic information about project location, what work categories may apply to your project, description of the aquatic environment, which includes a description of the biological and physical characteristics of the site, potential effects of the proposed project, including whether you're able to incorporate all the measures to protect fish and fish habitat, species presence, including species at risk, avoidance and mitigation measures to avoid any, to reduce or avoid any potential impacts on the aquatic environment, and additional project-specific details. So my experience has been for long-term licensing type projects, typically having your completed Water Act application and supplemental documents prepared prior to the submission of the DFO form really helps expedite the information that's included in the request for review form that you see on the screen. So the timeline for response varies. In Alberta, when you submit the form, it actually goes to Ontario and is typically reviewed if it requires a project-specific review through the office in Manitoba. So when you first submit that form, it goes to the triage department. They review it. You'll typically get a response within 4 to 8 weeks for projects submitted in Alberta. That response will tell you whether or not your project requires a project-specific review. If it requires a project-specific review, it's typically another 4 to 8 weeks for that review to actually be conducted by habitat biologists and hydrologists as well. If it doesn't require project-specific review, then that triage department response is kind of the end of that review process. One thing that I have found is that recent experience with COVID-19 and DFO staff having intermittent access to servers is the timelines. You're looking at 1.5 to 2 times that normal timeline. And it should also be noted that there are no regulated timelines for the DFO review process, unlike authorization. So I would recommend that you engage a qualified professional early in the process to limit the impact to schedule. So currently the AER is planning inspections on sensitive water bodies in areas with a history of non-compliance. The AER has released a bulletin recently where they've indicated that there's been a number of non-compliance from proponents on the water bodies in Alberta. So they have inspections planned and I think currently underway for the spring and upcoming summer of 2020. DFO is actually in communication with provincial regulators and they're looking to potentially coordinate on an inspection blitz. DFO typically doesn't have a big presence on water bodies in Alberta, but my understanding is that is about to change. And so the worst case scenario would be, a non-compliance with the Federal Fisheries Act and Species at Risk Act, damage to your social license in areas that you do business, and corporate and personal liability for fines per day, as well as possible imprisonment, which is unlikely, but fines are definitely a tool that is used for regulatory compliance. And it should also be noted that each day a non-compliance occurs is considered a new occurrence, and fines can be significant. So DFO has also opened discussions with the province to reduce the need for this quote double review. However, I've been told it will not be a formal agreement, and little progress has been made to this point in time. So how much and how long do they take to complete? So it really depends on the experience of the qualified professional completing the work, the availability of project information, the quality of publicly available data, whether a field program is necessary, and what the potential project activities or design of the water intake infrastructure is. With a reasonable amount of information available, we've seen costs of around $1,500 to start. Typically, these forms can be filled in pretty quickly by experienced professionals, and turnaround should be sometimes as little as a day. Where additional information is required to be collected, then obviously the timeline for completion may be impacted. So, we've prepared, submitted, and received approval for over 20 term licenses in Alberta and BC. We've had the opportunity to be in close contact with the provincial and federal regulators. My recommendation to everybody, whether it's consultants or proponents that we do business with, pick up the phone, ask the questions, and get second opinions if necessary, because the Fisheries Act has changed, and I just want to make sure that you guys are covered. And so that ends my presentation for today. Thank you very much, Joe and Isa, for having me today, and I'd welcome any questions. You're welcome to give me a call or email or through this forum as well.
Thank you so much, Robert. Thank you, Integrated, for doing this today. I really appreciate it. I have one question here. Just for everyone, yes, the slides will be available. They'll be available at the end. Everyone will get an email at the conclusion late Friday or over the weekend with links. Where can I find the self-assessment document is one of the questions.
Yeah, so the self-assessment process has been removed. It was something under the previous Fisheries Act. And when I say that, the term self-assessment has disappeared. If you just go to Google, you can type in DFO and projects near water. The projects near water website through the DFO has I believe it's a 6-step process that will walk you through, and so all the measures to protect fish and fish habitat are included there. The list that I gave are most relevant to water withdrawals, but again, there's other water bodies, there's other project activities that can be excluded from the review process, but water withdrawals in Canada, unfortunately, are not excluded from the DFO review process.
Okay, great. Since we're short on time, and sorry, Robert, we ran out of time for questions, and we have another webinar starting in a couple minutes. I'm going to end this one, and we're going to get the other one set up, and we'll get it going. So thank you for all the presenters in our first stream on regulatory updates. Really appreciate everyone's time and efforts. Be back online in a couple minutes. Thank you.